Welcome to Absolute Trust Talk with your host, Kirsten Howe. Absolute Trust Talk brings you tips, tools, advice, and interviews to help you build a reliable knowledge base on estate planning, business, and finance to start preparing for your future today.
Hello and welcome to Absolute Trust Talk. I am Kirsten Howe and I am the managing attorney here at Absolute Trust Counsel. I'm really glad that you're here today because we are going to be talking about one of my favorite things, which is celebrity estate planning or lack thereof. And of course, we are always talking about what can we learn from celebrity estate plans. This plan that we're going to be talking about, or lack thereof, is a young man named Liam Payne, and he was a performer. He was a member of the band One Direction. You may remember that last fall, he died very tragically while staying in Argentina. He fell from a hotel room window. And this is of interest to us because he died without a will. He's a very famous person. His estate is estimated to be worth about $32 million. Very sort of complicated estate. He had income that he'd earned being a performer in the band, income he earned as a solo artist. He had brand deals. He had music publishing rights. He was involved in various venture deals. So not your basic, house and a bank account type of an estate, a very complicated estate. And he died without a will. He had a child, an 8-year-old son named Bear. And he was not married, but he had a girlfriend that he lived with. And as I said, died intestate. So we're going to talk about today what we see, what I see in that situation as problematic. So the basic problem is that he did not have a written estate plan. And why is that a problem? Well, number one, we're always worried about probate in California. Now, I'm going to point out, I'm talking to you as a California lawyer, and I'm presumably talking to California listeners primarily. But we're going to be talking about this under California law. He was a resident of the UK, so the laws of the UK apply to him, but we're going to analyze this case as though it were under California law. So in California, we have a probate process. We're always trying to help our clients plan to avoid that process because it's very lengthy and very expensive. In this case, a $32 million estate, we don't know what the probate fees would be because in California, there is a statutory fee that the attorney gets and the executor gets. It doesn't go up to $32 million estates. The code just says after $25 million, the court will figure it out. If this were a $25 million case, those statutory fees would be $376,000. Okay, so most families would choose to avoid that if they could. And that is pretty basic planning. Avoiding probate fees, that's basic planning. It's not complicated. It's nothing fancy. It's what we do all day, every day. And that's not the end of it. As I said, the court would figure out what the fee should be for that extra above $25 million. And the attorney fee and executor fees are not the end of it in a probate. You got court fees, you have appraisal fees. And in this case, the assets are very complicated. It's not a bank account. It requires licensed appraisers to value these various unusual alternative type assets. How do you evaluate music publishing rights? So things like that, that's going to cost money too. It's also going to take time. Our California probates are taking a year to a year and a half. I would imagine a complicated one like this is going to take a bit longer just to get the control of all the assets and to get valuations on all of the assets. Okay, so he did not plan to avoid probate because he didn't have a plan. He also did not plan who was going to manage these assets for the benefit of his son, who is his intestate heir. This child is 8 years old. He's not going to manage his own assets. He, cognitively can't, and legally he can't until he's 18 in California. You have to be 18. So a guardian has to be appointed or a court has to create a trust for his benefit. Once he turns 18, he gets the money. In California, he would get that $32 million when he turned 18 or whatever's left of it by that time. So by dying intestate, Liam Payne did not choose who was going to be managing his son's money for the next 10 years. Who ends up managing it is his ex-girlfriend, who is the mother of the child, plus a music industry lawyer. They're going to work together on managing that money for the son. But Liam Payne didn't choose those people. Maybe he would have chosen them, but maybe he wouldn't. He didn't have a chance. Also, the 18 years old, very few parents, and I'm going to say in my practice of, a lot of years, I can probably come up with just one handful of parents who said to me, oh yeah, I think 18 years old is perfectly fine to inherit a whole bunch of money. The vast majority of my clients would say 18 is too young. Let's maybe wait till 25 or something like that. So this child's going to get $32 million or whatever left of it at the age of 18. And, we'll see what happens there. Also, by not planning for this inheritance for his child, he didn't leave anything to anybody else because this child is his intestate heir. This child gets all of it. Liam Payne was a young man. He is survived by both his parents. He has 2 siblings, I think I read. I would guess that given the size of his estate, he might have wanted to be generous with other family members. And especially when you think about an 18-year-old getting $32 million, no 18-year-old needs that much money. It would have been prudent from a lot of perspectives to spread the money around a little bit. And he's also got the girlfriend that we mentioned who lived in his home. I don't know that it was his home. I'm just assuming because he's got $32 million that he owned the home that they lived in together. And as an executor of this estate, you owe a duty to the beneficiary of the estate, which is the child, not the girlfriend who lives there. So legally, the girlfriend either has to leave or has to start paying rent if she's going to stay there. So that's a whole thing that he probably wouldn't have wanted. He wouldn't have wanted his girlfriend thrown out the day after he died. If he had written an estate plan, he could have planned for all of that. And perhaps he would have wanted to leave something to her too. So a whole lot of things went wrong here because he did not have a written estate plan, not the least of which also is taxes. In the U.S., a $32 million estate would be subject to estate tax. There would be, close to $20 million in excess estate, probably $18 million, subject to a 40% estate tax. That's a big check that this family is going to have to write to whatever the British equivalent of the IRS is. In the US, that's how it would work. In the US, if he had done planning, he could have done some planning to limit, minimize, or even avoid that estate tax. That's what wealthy people do. But he didn't do any written estate planning, so the tax is going to be the full 40% on $18 million. A lot of things could have been better in this case. The basic lesson is don't die intestate. And I think an even more important lesson here is these kinds of things can happen at any time. He was a young man. He was in his 30s. He wasn't expecting to die, but he did. And the outcome is not great. It's not ideal. Everybody with any kind of wealth and people that you care about, no matter how old you are, you need to do planning. Okay, I hope you enjoyed this. I hope it was entertaining. We always like to look at our celebrity estate plans, and I hope you learned something. So thanks for joining me, and I look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.
This podcast is not meant to take the place of legal advice from an attorney and does not create an attorney-client relationship. If you do have a legal question or issue, please consult with an attorney.